morning, Professor Verdeguer. Thank you for participating in this mock session of the Jean Monnet Network on EU-China relations, and specifically about your work on competition law and policy, global governance, and EU-China relations. We would like to ask you, which risks do you consider are associated with the lack of a sound global governance framework of competition law? And which solutions are there?
As regards to your question, I think that we are witnessing a large number of extraterritoriality issues and multi-jurisdictional problems that arise from the spread of cross-border operations. And the thing is that while markets are increasingly going global, rules governing competition remain national in scope. For instance, picture the classic price-fixing cartel between, let's say, American firms, but it turns out that those American firms do not operate in US soil, but also in that of the EU. Or maybe they don't even operate in the European Union, but their anti-competitive activity is somehow affecting the EU's internal market. So anyhow, in any of these cases, I think that we are facing a single conduct whose effects have an impact on two different jurisdictions. And other case will be that of a merger between companies operating in a number of countries, whose respective merger control thresholds are met at the same time. So in this case, parties to that merger have no other choice but to file before the competition authority of each and every one of these jurisdictions. So basically all this unavoidably gives rise to inefficiencies in terms of time management, resource allocation, market performance, and for sure, if there is no type of cooperation between jurisdictions in this regard, there may be like greater chances of overlooking some cases worth looking into. And also there may be difficulties for the competition authority, for the reviewing authority to collect evidence when the facts didn't take place in its territory. Also possibilities to enforce sanctions in other territories are quite scarce or scant, not to mention the possibility for the parties to come across divergent outcomes for the same case, or on the same case. And the list goes on, you name it. So eventually all these, where all these consequences lead, so they clearly lead to legal uncertainty in international markets. And which options can we think of to address the lack of a comprehensive global governance framework of competition policy? Some experts argue in favor of the establishment of an international common enforcement authority. So this solution seems to be like quite unrealistic, I would say, or too ambitious. So even though we have the paramount example provided by the EU, which is worth looking up to, we should not forget that the case of EU competition policy takes place at the core of probably the most committed regional integration process in the world. So I guess that you would agree with me that taking the EU example to the international arena seems to be quite over the top. Especially if we take into account that it stands to reason that the creation of a single authority will very likely go hand in hand with a common set of rules, an international antitrust code, if you want to put it that way. So I, for one, I'd be more supportive of a more flexible approach to global governance instead of conferring powers on a common international authority. I guess that it's more appropriate to make use of guidelines, recommendations, best practices. So in essence, non-binding instruments. And this is what we actually are somehow doing nowadays, because we have the International Competition Network, we have the OECD, and they are proving to be extremely useful for the international competition community. So they are truly making inroads towards like a healthy common understanding of competition around the globe. So to me, this is the key to achieving like sound competition policy principles.
So which role do you think multilateral agreements are playing in this sense nowadays?
Basically, I feel that when it comes to soft ways of cooperation on competition between jurisdictions, hands down, the bilateral and multilateral agreements can really do the trick to cope with extraterritoriality issues or multi-jurisdictional problems. So these agreements also deliver other advantages, as they can easily include anti-dumping provisions that may help counter predatory pricing and other behaviors. So when we look back on time, actually history speaks for itself, as we can see a large number of bilateral agreements successfully concluded with competition policy provisions to be found in their wording. So we can claim that without international agreements, countries or trading blocs would end up like hampering their own markets, as there will quite obviously be an under-enforcement of cross-border anti-competitive behavior. So in this regard, I think it's worth mentioning that it's easier to come to terms on competition policy issues when countries have like common grounds or shared economic interests. So this for sure takes place, especially between jurisdictions that belong to the same region. So the fact of being geographically close to one another often facilitates a more feasible form of harmonization, I would say. So we can see this in regional organizations such as the Caribbean Community, the CARICOM, or the Association of Southeast Asia, not to mention the case of the EU. Because when the EU concludes free trade agreements with third countries, you frequently observe provisions on competition policy in a soft way to seek convergence. And you can take, for instance, the agreement with New Zealand, which has been recently signed, and there is a whole chapter on competition policy. And China is also very good at this too. China also makes use of free trade agreements as like soft convergence mechanisms on competition policy. If I remember rightly, there are like over more than 20 agreements of this type in force between China and third countries. It's well known, for instance, the free trade agreement between China and Australia, which sets out how their respective competition authorities should work together by exchanging information by means of technical cooperation for notification purposes or enforcement, by sharing viewpoints in cases which are subject to the common review by both countries or by both parties. And a whole different story will be given if mutual recognition clauses were to be found in these agreements. A mutual recognition clause is like a provision that compels an authority to apply domestically a decision that has been delivered by the enforcer from a third jurisdiction. Therefore, a free trade agreement with a mutual recognition clause is not as soft as it is a free trade agreement without this type of clause.
And lastly, have the European Union and China traditionally cooperated on competition policy issues?
Both the EU and China consider that it was like in their best interest to reach a mutual understanding of competition. So bearing in mind that the US and the EU have traditionally been regarded as a reference for emerging jurisdictions, China showed since the very beginning a preference for the EU's regime over that of the US. So like very broadly speaking, it's thought that since the US is a stronger advocate for market self-correcting mechanisms, China opted for modeling its anti-monopoly law on EU's competition law. But even though materially speaking, the Chinese law is modeled that of the EU, there also are like obvious variations in application due namely to the Chinese competition authorities' embeddedness in the central bureaucracy and its social market economy principles. But despite the differences between the EU and China, the relationship between them has grown since the birth of the Chinese competition law. And like in every relationship, China and the EU also have had like their ups and downs. Last years have revealed like a larger European distrust or mistrust of Chinese activities in Europe, and like an increased will of laying down stricter controls. Take for instance like the international procurement instrument to limit the access to EU public procurement tenders of non-EU companies that do not from countries that do not offer similar access to EU companies, or the EU's regulation on foreign subsidies. But at any rate, and as you can see, it looks like the EU is trying to work out those differences with China, namely through trade defense mechanisms rather than making use of competition rules. And having said that, and going back to the cooperation between the EU and China, as I said in the previous question, the European Union concludes a great deal of free trade agreements, but it also concludes specific agreements on competition, and this is precisely the case of the EU and China, where there is like a whole chapter, a whole agreement on competition law, a dedicated agreement on competition law issues with special support of the EU to the development of competition law in China. So if we go back in time, since late 2003, even long before the enactment of the Chinese law on competition, the EU opted for the establishment of an institutionalized dialogue with China, where support and technical assistance were like key drivers for the development of Chinese legislation on competition. After that, that institutionalized dialogue that I'm talking about, that led to the so-called competition policy dialogue, which consisted in the establishment of a permanent consultation mechanisms, and also under the presidency of Manuel Durão Barroso, a memorandum of understanding was signed in order to exchange information on competition law in a soft, harmonizing kind of way. So basically experiences, technical issues, initiatives, and so on. And also, like with China, similar cooperation remains open to other Asian jurisdictions on the part of the European Union. There's an European Union program fostered by DG Comp that includes, besides China, other jurisdictions such as India, Japan, South Korea, Philippines, Singapore, Thailand, Vietnam. I know for sure that it ran from 2018 to 2020. I don't know if it's been renewed, but I can tell that the project intended to promote regulatory level playing field for the mutual benefit of all the jurisdictions involved. And because of that, the European Commission launched like a series of summer courses on competition law for officials of the different national competition authorities, lectures, a range of lectures held in the participating countries and delivered by DG Comp officials, by officials of the European Commission, internal training. So that's pretty much like, I would say, like a brief overview of the cooperation between the EU and China on competition policy issues.
Thank you very much, Professor Verdeguer, for providing us with this insight on competition. It was a pleasure. Thank you.
Thank you. Thank you.